Hello and welcome to this episode of Criminal Justice Natters with me, Ed Johnston. Today we are joined by Dean Strang, who was one of the lead defence counsel in the Steven Avery case. We discuss obviously the Avery case, general problems within the criminal justice system, as well as a brief discussion on two of Dean's recent publications, his two books. So I hope you enjoy. Let's get to it. Hi, Dean. Thanks for joining us this afternoon. I know you're extremely busy, so I really appreciate you giving us your time. And unsurprisingly, we've had a number of questions in concerning making a murderer, the Steven Avery case, and your career in law. So we'll just jump in if that's okay with you, and we'll make a start. How did you end up with the Avery case? How did that land on your desk?
Well, I had just recently finished a stint as 5 years as the federal public defender in Wisconsin. I had ended that 5-year tenure just about 6 months before I took the Avery case. And I was eager at that point, going back into private practice after a 5-year hiatus in public defense. I was eager to show people that I could still find a state courthouse, that I could still practice in state court as well as federal court. And a former partner and mentor of mine was Steve Glynn, who appears in Making a Murderer, especially early, along with Walt Kelly. The two of them were representing Steven Avery on his civil action, seeking damages for the wrongful 1985 conviction. After Steven was arrested and charged on the new criminal case in November of 2005, he very quickly, I think, was expressing the common bias of many people charged with crimes in the United States, that he wanted a retained defense lawyer, not a court-appointed defense lawyer. So he settled the civil case to raise money to retain criminal defense counsel. And both Steve and Walt suggested me as one of the lawyers he might consider. And I know they gave at least a couple of other names as well. But Steven's family contacted me. I went to visit him in jail. It seemed like a good fit, I think, on both ends. And so that's how I got involved in February of 2006, about 4 months roughly after Steven was charged. Steve Glynn and Walt Kelly also had given the Avery family Jerry Buting's name. And when I learned that was sort of a happy circumstance from my perspective, because Jerry and I had collaborated before on cases, and I knew our skills and interests to be complementary. So I suggested to Steven, why don't you think about hiring Jerry as well, since you're considering it, and maybe you want both of us. We can make the money work between the two of us. So, that obviously was going to reduce the actual fee either of us got, but we could make that work, I thought, and that it would be, a good team to work with Jerry. And that's ultimately what Steve and his family decided. So Jerry joined the defense about a week or 10 days, something like that, after I did.
Yeah. In terms of working with Jerry previously, were they on cases as large as the Avery case, as serious as the Avery case?
Well, of course, every case is large to the person accused.
Very true.
Or the person who's a victim of a crime. But in the way you're asking, I would say no, not quite. And certainly not as widely followed by the media or the general public. Jerry and I had never been law partners. We simply had collaborated often where, he might represent the husband and I might represent the wife, or,
Yeah.
boyfriend and girlfriend or something like that. I think this was the first time where we collaborated to represent the same client. And yes, I think I can't think of an earlier, off the top of my head, I can't think of an earlier murder case, for example, on which we had worked together.
You said that Stephen and his family wanted to have a retained lawyer opposed to state-appointed lawyer. Could you tell maybe our viewers just the differences in the benefits of having a lawyer that's retained?
Well, they're pretty mixed. I mean, in this country, public defenders, those who actually work for an institutional public defender, often are among the most skilled defense lawyers we have. And then there are other, what we describe as private bar members, who routinely accept court appointments in indigent cases where for some reason the public defender's office has a conflict of interest or can't handle a case as a matter of workload. And, among those private lawyers who accept indigent appointments, which I think is closest to the UK system, there I would say, the quality is very mixed. The skill level is very mixed, and the caseload, and therefore the available time, varies greatly among that segment of the bar. But I think often the reason for the bias that so many accused express about public defenders or court-appointed counsel is, one, you can't pick your public defender or your court-appointed counsel. You don't get, unlike in the UK, you don't get to go out, hire, sort of retain that person and then they work on a voucher. Rather, the court or the public defender's office picks your lawyer for you. So there's a loss of control by the accused. And then I think the second reason is, many defendants find from bitter experience that the caseloads that public defenders or court-appointed counsel are carrying are just too high. Too many cases, and you don't get more than 24 hours in the day just because you've got an enormous caseload. Yeah. So clients can end up frustrated with their inability to reach the lawyer on the phone or to have the lawyer visit in jail frequently. And so there develops a bias in favor of retaining counsel, a bias that's really not always warranted. Again, you often can get one of the best lawyers in your area for free through the public defender's office, rather than paying for somebody who may not be as skilled. But that doesn't alter the common bias among people charged with crimes.
Okay, thank you. To return to the Avery case, when I spoke to Jerry a couple of weeks ago, we spoke about this civil suit and how Jerry believed that impacted the sort of investigation and desire to pin this on Stephen. Would that be a viewpoint that you would share?
Sure. I mean, absolutely. It was the underpinnings of everything in the early investigative stages. It's why the local sheriff's department purported to recuse itself from the investigation. That actually wasn't the reality, but it made a public show of handing the investigation off to the neighboring county's sheriff's department. And throughout the antipathy of the Manitowoc County Sheriff's Department and the local, criminal punishment apparatus in Manitowoc County was evident, in a variety of ways. So, that was part of the context in which the case arose and in which it was tried.
Yeah, and I always find it interesting watching the documentary about how the local law enforcement did recuse itself from the investigation, yet they were the people who found the key in after, however many searches of Stephen's property, and then the blood in the car. When this sort of came to you, what was your first sort of thought on that, the key in particular? I mean, that was in plain sight.
It was yeah. They claimed it was in plain view, and and the film they had of it had it in plain view. But as Jerry and I began to go through the police reports that were disclosed to us, in what's called pretrial discovery here, and look at the preliminary hearing transcript that had already occurred while Stephen had court-appointed counsel. As we began to acquaint ourselves factually with the case, there was a growing recognition that not just the key, and not just the bones and the bone fragments in the burn pit, but every significant piece of physical evidence either first was discovered by a member of the sheriff's department that purportedly had recused itself, purportedly was not involved actively in the investigation, or had first been in the custody. In the example of the car, which at least the testimony was that a private investigator first located Teresa Halbach's car on the Avery salvage yard property, but who was it who went to the car and who maintained the perimeter around the car? It was the Manitowoc County Sheriff's Department, the very people who weren't to be actively involved in the investigation itself. And that continued to be the pattern with, truly every piece of significant physical evidence first was discovered by, or reported by, or under the control of this recused sheriff's department. So it put the lie to what the sheriff had said his department was doing in the investigation. And it raised, I think, perfectly legitimate questions about, why the public had been deceived in this way.
Yeah, it was. I always liked it when you're watching the documentary. What struck me first of all was like it was so compelling, and you have these feelings of what the hell's going on here, and you kind of forget that this is true life and that somebody's life is at stake here, someone's liberty is at stake here. So how did that, with the sort of constant filming and almost to the viewer, it felt like this could be scripted television and still be compelling. How did you cope with the constant filming of almost your every move in terms of the sort of pre-trial preparation and then the trial?
Well, of course, I was watching real life unfold, not watching a movie.
Yeah.
And the filming was just something that was in the background most of the time. These documentarians were not the only people with a camera by any means in this case. All of the 7 media markets in Wisconsin had television reporters and cameras there. There were radio, reporters. There were print media reporters. There were any number of freelancers and members of the media around. Many of them with cameras. So, very quickly out of court, the filmmakers were just one more, small group of people behind a lens. And in court, the filming was quite unobtrusive because there was a media room separate from the courtroom, but able to view the courtroom through a picture window that separated the media room from the courtroom. And then the cameras in court were of the ceiling mounted surveillance type that
Yeah.
are so familiar to all of us now, remotely controlled. So you really weren't aware when you were in court, especially of filming. You were aware in the sense that we of course knew this was being live streamed and it was being filmed, but you didn't have, cables duct taped to the carpet of the courtroom. You didn't have people walking around with television cameras or still cameras. You didn't have cameras on tripods. You didn't have visible microphones. So there wasn't much distraction while we were in court from the filming process. Now, there were with these documentarians the times where they filmed us out of court, in an apartment, one of the apartments we had rented during the trial, for example, or later after the trial at our respective offices. And those shots in the documentary were not ambushes by the filmmakers. They talked to us by email or phone and asked permission and scheduled, and we worked out what we thought they could film without intruding into either our time and our duties to our client or into the lawyer-client privilege. And they were quite cooperative and respectful of the fact that we had a very different role than they did as documentarians. And some of that footage, was shot either well before or well after the trial and the sentencing. So, the discomfort a lawyer feels when on camera or when faced with a scrum of TV reporters when you come out of the courthouse or the courtroom, that goes away if you've had experience with widely followed cases. It goes away, or at least it diminishes with time.
Yeah.
So I understand why the viewer of a film, when all this this year and a half process gets distilled to 10 or 11 hours, I understand why it can almost seem scripted or unreal. And of course, its particular setting is unfamiliar to most viewers. Most people have never been to Manitowoc County, Wisconsin. Why would they? But the experience in real time on the case was not akin to what you're describing.
Okay, thank you. You mentioned the media scrum, and one of the things that sort of really gripped me whilst watching the documentary was the sort of daily press conferences post-trial. And when I spoke to Jerry, I brought it up, and I said it was almost like an American football coach or a sports coach kind of post-game going in and digesting everything that happened. And in England and Wales, that simply wouldn't happen here, to have sort of daily briefings on what had happened. And I wondered if that was commonplace in the United States, and Jerry said it wasn't. And I wondered why that occurred then. Was it for prosecutorial gain, or was there another reason behind it? Or
well, first of all, Jerry is exactly right. That is not commonplace. Indeed, it was a one-off in my experience. I've never had that kind of press briefing daily or at all, during a trial, and don't expect to ever again. I mean, I like your analogy to the post-game comments of an American, football coach or baseball manager, but which is an apt analogy, but it really was freakishly rare here, for something like that. And the first and only time I've been involved in that. So your question is, why do that? Well, excuse me. Very early, in fact, the day that Jerry Buting got retained to join the defense team, the lead prosecutor, Ken Kratz, gave a televised press conference. And we thought that wildly inflammatory, unfair, and very harmful to, the fairness and objectivity of a later potential jury. So we went to the court for sanctions on that, and indeed we asked to have the case dismissed because the harm was irreparable from a press conference that we thought crossed ethical boundaries and simply was unfairly prejudicial. Wouldn't and couldn't have happened in the UK, but here,
Yeah.
Here we've got a sort of a more robust culture of pretrial publicity. Nonetheless, there are limits even here, and we thought this had exceeded them. The judge had, not surprisingly, declined to dismiss the case, and he did not even enter what we would call a gag order here. He didn't formally restrain the lawyers on both sides of the case from any public comment. But informally, in chambers, the judge said, I don't want to see something like this again from anybody, from either side, at least of the lawyers. You can't restrain what the victim's family might say, but the lawyers, as officers of the court, the judge made very clear, even if informally, that nothing like this better happen again. And from that point forward, the prosecution team was pretty muted, other than whatever in-court arguments they were making, which is perfectly fair game, and we were similarly muted. And then I think it was during jury selection, actually, it was immediately before the trial proper was to begin. Ken Kratz, again in chambers with us present, broached to the judge the proposition that the media and the public were clamoring for updates from him, and that this was a case of wide public interest, and he as a public official should be making some appropriate comment during the course of the trial. Moreover, he said that the spokesperson for the Halbach family, who viewers of Making a Murderer know as Mike Halbach, one of Teresa's brothers, Mr. Kratz announced to the judge that Mike Halbach intended to have regular press conferences or make regular, maybe daily comment to the press. And so what Mr. Kratz proposed in chambers, as I recall it, was that on one day, Ken Kratz would hold a press conference after court was concluded for the day and suggested the parameters of that press conference. And he wanted the court's permission, at least informally, to go ahead that way, notwithstanding the judge's earlier directive that we should avoid much public comment at all. Then Mr. Kratz added that on the days when he was not speaking, on the alternate day, Mike Halbach would have a similar press conference. And then the day after that, back to Ken Kratz, and so forth. And, the judge's reaction, as I remember it, was, well, you have rules of professional conduct. I can't tell you, how to abide by those. I'm warning you that you better abide by them. But under our rules of professional conduct for lawyers, there is some space for public comment, even during a trial. And so what Jerry and I decided, Ed, was that if the public, through the media, was going to hear the prosecutor on odd numbered days and going to hear the victim's brother on even numbered days, that we had a duty to our client to have his perspective heard too, or at least, to defend the sanctity of the presumption of innocence and and ask people to withhold judgment until all the evidence was in and the jury had spoken. And so we decided, well, then we'll speak too if they're going to do this. So we worked it out informally with Ken Kratz that what the parameters of this would be, and that we actually would share the podium and stand behind the same lectern, one after the other, in the media assembly room that had been set up in the basement of the courthouse. And we agreed that none of us would comment prospectively on evidence still to be heard, but that we could explain what had happened in court that day.
Yeah.
If it was unclear to the media or therefore to the public. And Mike Halbach largely agreed, to live within the same informal parameters. And so that's the way it went forward. And I think, on one day, Ken Kratz and Mike Halbach would go first, and Jerry and I would stand to the side off camera. And then when they were done, we'd take the podium and stand behind the lectern. And then the next day we'd do it in reverse order through the trial. So that's how it came to be. It was weird. And again, I'm not looking to repeat that, but I also think that both Messrs. Kratz and Halbach, conducted themselves within ethical bounds, certainly Mr. Kratz, within ethical bounds, as did we during the course of those daily press briefings. Whether they were desirable or not, that's another question, but I didn't see ethical hazard actually occurring with those on either the prosecution or the defense side.
Okay, thank you. In terms of the sort of fair trial rights of Steven, do you think there was sort of any infringement to his right to a fair trial by not being able to allude to other potential suspects during the trial, or do you think it was fair that sort of idea was excluded by the court?
No, the former. I think it was unfair that he was not allowed to make real the reasonable doubts about his guilt by, sort of setting them tangibly in the context of one or more others who realistically might instead have been Teresa Halbach's killer. And I think generally in the law of English-speaking countries, the alternate perpetrator is viewed as relevant and admissible evidence. The United States in general is probably more restrictive on that than Australia or Canada or England or Scotland, Wales, Ireland for that matter. And Wisconsin is especially restrictive even in the United States. Wisconsin in large part because of this case. So, as you probably know, the rule in Wisconsin had been that an alternative suspect can be the subject of defense inquiry and evidence if, there was a reasonable possibility the person could have committed the crime. They were physically proximate to the scene of the crime, and otherwise reasonably could have committed the crime. And also one had to make some showing of possible propensity to commit that sort of offense. But to those two steps, this trial judge added, and the Wisconsin Court of Appeals ratified later on appeal, a third evidentiary requirement, which is that the defense now has to demonstrate motive of the alternative suspect to commit the crime. And that presents a sort of preposterous outcome, really, because take a case like this. So now the question is, the defense has to make some showing of motive of the alternate suspect to murder Teresa Halbach. Well, of the 7+ billion people on this planet, absolutely nobody had a motive, had a reason to want to kill Teresa Halbach. She had given no offense to anyone, so far as I know. She'd led a blameless life, so far as I know. She wasn't, in other words, a drug dealer who, was ripping off customers. She wasn't breaking up a marriage in a love triangle. She wasn't doing anything that would have given someone a motive to want to kill her. And yet somebody did kill her.
Yeah.
And in recognition of exactly that, problem with motive, the prosecution in a murder case, and in most criminal cases in the US, is never required to prove motive. It's not an element of the crime the prosecution has to prove. And yet here, the burden was put on the defendant of showing motive to kill Teresa Halbach, even though, the entire burden of proving the crime rested on the prosecution in the US as in the United Kingdom. So it was very peculiar and upside down, so far as I'm concerned, doctrinally, and it has this freakish result of having the availability of an alternate suspect, Ed, turn on the character of the victim, not on anything else that might actually be relevant to a crime. But in other words, a murder victim who was up to no good or had given people reason to want them dead, in that case, you might well be able to defend by proving motive of others to wish the decedent harm. But in the case of a blameless victim, you don't have that defense. And that really, I think, is logically unjustifiable. But that's the state of law in Wisconsin, and it was unfair.
And is that still the state of law in Wisconsin today, that you still would have to prove the motive?
Yes.
Yeah. Oh, wow. Yeah, that seems extremely unfair, especially if the prosecution don't have to prove the motive of the defendant either.
No, and indeed the jury is instructed that the prosecution doesn't have to prove motive.
Yeah. Okay. In terms of Brendan's interview with the two officers early in season 1, what struck me there was the lack of either defense representation or an appropriate adult. And what I think everyone can see is he's eventually coerced psychologically into believing that he was sort of led down the line, and then the officers just gave him the words to say effectively. Are there no protections for juvenile suspects whilst being interrogated in the US?
That's more complicated. First, let me say that Brendan's experience is very common, very common.
Wow.
Certainly was in 2006 when he was interviewed in custody, and today in late 2020, it would remain very, very common, thousands of times, tens of thousands of times a year. It's probably still the norm, actually, in the United States. Now, that said, Brendan's case specifically, I think, has raised a fair bit of awareness of this problem and its unfairness. It's just inherent unfairness and unacceptable risk for producing a false confession.
Mm-hmm.
So we've seen some efforts, modest, I think, but nonetheless real efforts at reform in 2 or 3 or 4 states. You've seen legislation since 2015, really in part because of Brendan Dassey's revealed experience in that
Yeah.
movie, where at least for very serious crimes and for children under, a threshold age,
Yeah.
15 or 16, a custodial interrogation cannot go forward without either an appropriate adult, a guardian or parent,
Yeah. Yeah.
or counsel being present. But that is still not the anywhere close to the universal rule in the United States. In fact, it's still the minority rule. And all I can say is there's some movement in that direction. And the filmmakers of Making a Murderer, I think, deserve some credit for the impetus toward some greater protection of juveniles in custodial interrogation.
So when you say custodial interrogation, do you mean at the police station?
Yes, typically, although in theory one could be in custody in your own living room.
Yeah.
Yeah, but in other words, when the police have prevented you from leaving,
Okay. Yeah.
either by formal arrest or by taking functional steps through which a reasonable person would
Mm-hmm.
perceive himself not free to leave or to terminate the interaction with the police.
Because
Typically, it's at the station house, but it doesn't have to.
Because my next question was going to be, well, could that rule just be circumvented by interrogating the suspect somewhere outside the police station? But if it's the formal steps of,
yeah, the question is whether you're under arrest.
Yeah.
And that gets sticky here, but the basic idea is, would a reasonable person in the suspect's position view herself as free to end the encounter and to leave?
Has there been, so, the documentary makers had sort of, illuminated that issue of juvenile interrogation. Has there been any other sort of benefits from having this documentary of this whole investigation trial sort of in the wide public eye? Has there been other tangible benefits to the criminal justice system?
To my mind, yes. At least if by tangible benefits we mean to the public
Mm-hmm.
at large and to popular perception. How much of that is translated into actual change in the criminal justice system in the teeth of resistance by the institutions that have a stake in the status quo. That's a tougher question, but I do think that Making a Murderer, along with a number of other well done podcasts or documentary films in the sort of true crime area, have propelled or fed a broader conversation in the United States and in the rest of the world that's had access to things like the podcast Serial or David Rudolph's case and the documentary made of that, or the Durst case. There've been a number of, I think, pretty thoughtful, well-produced true crime depictions in the years immediately before and since Making a Murderer. And I don't think there's any way to dispute really that there's a current crest in the interest in true crime and in whether the criminal justice apparatus is serving the public well, serving victims, defendants, and the public more generally as it should. How the legal profession is functioning. So I think all of that, to the extent it has fostered public discussion and debate, has been good. And I will say specifically about Making a Murderer in the context of the United States, I personally think that the fact that this story arose in and therefore was located in a rural area with everybody visible in the case and on film white.
Yeah.
There's not a non-white person to be found in this. I think the coincidence of the rural setting and the fact that all of the visible actors are white has allowed this particular story to gain traction in our society, in U.S. society, in a way that it may not have, unfortunately, had protagonists been people of color, or had the setting been, a large city, a metropolitan area. Because I think, had this case arisen in Chicago and, with a racially and ethnically diverse cast, if you will, of real life characters, it would have been easy for much of America to deflect this as saying, well, now you're talking to me about race, and I'm not interested in, I've heard all about race. And now you're talking to me about big city problems. That kind of thing doesn't happen outside big cities. So, the fact of the setting in which this arose and the ethnicity of all of the actor, I don't mean actors in the but all of the people in it, I think, meant that it explodes some of the myths of the United States and its culture, and it kind of invites people to confront these issues as universal, which they are, and as not simply located in race or ethnicity or big cities, but that police corruption can occur anywhere. And that, what's at work along with racial bias in our criminal justice system is a persistent and pervasive orientation against the impoverished, against the lower socioeconomic strata in this country, regardless of racial or ethnic composition of the people in those strata. So that's, to me, a particularly useful accident of, the story that unfolds in Making a Murderer.
Do you think the document? I assume you've seen the documentary, or have you not watched it? You've seen it.
Yes.
Yeah. Do you think it was well balanced in terms of both sides sort of getting a fair shake, or do you think it was slanted in its kind of goal of what it was trying to achieve?
I don't think the goal of the filmmakers was slanted. I think their goal was, and this is visible if one looks fairly at it, simply to present the story of what happened, and then to challenge the viewer to make what she will of it. To struggle with guilt or innocence, to struggle with the complexity of that question, or the shades of gray inherent in that question, to struggle with whether police misconduct matters only if somebody's clearly guilty, or does it matter all the time? Is it a structural problem regardless of guilt or innocence, for example? Now, I also think that the filmmakers did a good job in distilling the prosecution case to its most important essentials, and in distilling the defense case to its most important essentials. The viewer gets, the theory of prosecution well, I think, and the theory of defense well. You and I, like anybody else, would have made some different editorial choices had we been the person behind the camera, or the person editing the film. Of course, you and I would have. But it wasn't our film. It wasn't mine. It wasn't yours. Wasn't anybody else's. And I thought the filmmakers were really quite fair in trying to distill 5 weeks of evidence and argument, a week of jury, selection, months of pretrial proceedings into, about 3.5 hours of film for the Avery case, and then another hour or so of film on the Dassey case, which itself was a, full 2 weeks of trial, plus a few days of jury selection. So, in that sense, I really do think they were fair. Now, one way in which the filmmakers were hampered through no fault of their own, Ed, is that they had much more willing participation from the defense team in Avery than they did from the defense team in Dassey or from the prosecution team in either of those two cases. So, I know that the filmmakers invited the prosecutors repeatedly to sit on camera for interviews, to, participate, and were rejected time and again by the prosecutors. And the filmmakers can't control that.
No.
And couldn't control the choices that the Dassey defense team made either. So, to some extent, they had to work with what they had.
Yeah. When thinking of sort of wider criminal justice issues, in terms of just what's going on with the state of play, what do you think, in your opinion, is the biggest problem within the criminal justice system in the United States? It's a hard one to pick one.
Well, any answer I give you will oversimplify.
Okay.
And exclude in a way that's distorting. But let me say this, that those who speak of the need for criminal justice reform, or those who speak of the need for reforming the police in some fashion, we're hearing a lot about both of those related calls today, are proceeding on the assumption that the criminal justice system is broken, or that policing is broken in some way. Why? Because it doesn't offer the equal administration of justice. And you would only view criminal justice as broken in the United States if you think that equal administration of justice is its historical and core purpose. Once you realize that the entire apparatus of these institutions was set up to provide social control, largely of the impoverished and unfortunate, for the benefit of the propertied and privileged, then you have to say, unfortunately, that the criminal justice system continues to do about what it was intended to do. It imprisons the poor. It deflects downward the life trajectories of millions of Americans who are in heavily surveilled communities in this country. And a lot of that, ultimately, in this country, gets you can find its roots in slavery, and more recently in efforts to maintain white supremacy after our Civil War ended, with the roughly 25 years of Reconstruction that followed. And slavery was abolished, but white supremacy was not. And the sort of white supremacist structures very quickly replicated or arose in ways that preserved the inferior social status of former slaves or people of African descent generally. And that simply remains true today. The racial disparities are enormous in our system. That's where they're rooted, and they've become quite linked to poverty, which, in my view, we we underdefine, we define too narrowly. We think of poverty as being a financial state of, impecunious sort of standing, inability to pay bills or afford decent housing. But poverty, I think, really is much broader and complex than that. You see a poverty of mental health, you see a poverty of education, you see a poverty of fund of general knowledge, poverty of coping skills. A lot of this tied to early childhood trauma and to generational trauma and poverty in a variety of the ways in which I think it ought to be understood and defined. And so, both policing as the front end institution of what we call criminal justice, and all of the institutions that follow it, prosecutors' offices, courts, corrections departments, and then the supervision people who keep former inmates or former defendants under government surveillance through court-ordered supervision. All of these institutions in assemblage really are doing today what they've always done, which is to control a disadvantaged segment of the population and surveil them for the benefit of the more moneyed or propertied. Now, that sounds awfully bleak, but to me, what that means is that calls for reform are superficial and inadequate. And it's not that we shouldn't take incremental steps. That's terrific to take incremental steps, and you probably can't blow up anything all at once, at least to good advantage. But if we're going to take incremental steps toward reforming the police or reforming the courts and electing, so-called progressive prosecutors, I think we need to have a broader end in mind and recognize just how deeply rooted and structural the problems are with our punishment bureaucracy from beginning to end. That's my view. So it all defies, unfortunately, a very satisfactory answer. And I don't want to suggest that this is hopeless, because nothing human is hopeless in the end. But I also don't want to get trapped in sort of a narrow discussion of, this or that reform idea at the moment, most of which involves nibbling around the edges.
Yeah. Okay. I know you've published a couple of books over the last few years. I wondered if you could just take some time to explain what they're about and how that came about. Is it an interest, or is it something you've just recently sort of thought, publish a book, or because it's that easy?
No, my first book came out in 2013, and was a project that I had been working on in earnest since 2005 and had been thinking about since the early 1990s. I'm either an amateur legal historian or at least a largely self-taught legal historian. My interest really lies in the experience in courts and with policing of outsiders and newcomers in U.S. society, especially during what we think of as the progressive era, roughly 1880 to 1930. I mean, that's a little both earlier and later than many people would define that era, but roughly in that era. So both of my books, which are legal history, are set during the 1917, 1918, 1919, the period of time in which the U.S. joins World War I, and the immediate aftermath of that, which was a time of considerable turmoil and repression. implemented by US courts in the name of supporting a frantic war effort. And so both of the books cover cases that arose in that setting with outsiders in US society, either because they were immigrants, recent arrivals, or they were radicals, or in the case of the first book, Italians, who were a very disfavored immigrant group in those years. And they simply look at the experience of these people in those particular trials. I think the parallels are there for a reader to draw to our current war on terror, to the time, the 21st century. And the names of the disfavored groups, their identities have changed over the year, whether it was the Red Scare and, the post-World War II concern about communism, and then the Vietnam War era with internal dissent and new radical groups arising, challenging the existing structure, civil rights movement, so the groups, the outsiders, if you will, change, the perceived radical threats change over time, but the viewer is invited to, sort of ask how much has changed on the government side of that, especially in the operation of our courts and policing institutions.
Okay. And so do both books cover that sort of 1880 to 1930 period, but with different cases sort of analyzed and examined?
Yes, both of the actual court cases. The first book, the 2013 book, kind of an otherwise insignificant prosecution of Italians in the city of Milwaukee in state court. And then the second book concerns a much more historically significant trial. It's the largest mass trial in US history in our civilian courts in any event. That was in federal court in Chicago, and it was the government's effort to break the industrial workers of the world, the most radical and rapidly growing at that time labor union. And so both of them concerned specific trials, and those trials were 1917, 1918. But the broader context, of course, both of Italian immigration in two successive waves to the US, and in the labor movement, the rise of the labor movement, and especially, the sort of left edge of the labor union that the labor movement that the IWW represented. That's a broader context of the period of time you and I have discussed.
Thanks. They both sound extremely interesting. I have one final question for you, and then I can let you go. I recently finished a study and submitted a manuscript just last night that looked at the defense lawyer in the modern era. And what I tried to discover is, how does a defense lawyer prioritize their duties? And I built a classic conception of the lawyer from sort of English law and a lot of American academic studies. And it comes to the duty of the court, the duty to the client, the duty to the court, and then the duty to the public. How would you, in your working day, prioritize that sort of hierarchy?
In the same way, largely, Ed. Duty to client first. Duty to court in a very concrete way, is always present, and it shapes the what is fair argument. It shapes or dictates what we fairly can rely on or advance to the court. But then in a broader sense, duty to the public, duty to the idea of liberty, duty to the idea of a free people who don't presuppose that the government is always correct when it accuses, don't presuppose that the police evidence is always reliable when it's advanced. Just to the spirit of liberty, and to trying to keep that alive in a time when autocrats and strongmen are increasingly appealing, even in what, think of themselves as democratic societies, and where we, this is all of human history, where we are always defining ourselves in contrast to some other, to some unwanted, unwashed other group. I think, the idea of humanity, a shared humanity, and a shared human interest and spirit of liberty is the broadest, and the most lasting duty of the defense lawyer. And we're not alone in that respect. I think journalists, educators, there's any number of people who share that orientation and that duty. But yeah, duty to clients specifically, duty to the court, of course, and then playing some useful role in preserving and advancing both the humanity and the liberty of the society in which one lives, seem to me the work of lawyers.
Thank you, Dean. That was extremely interesting, and I'm sure our viewers will enjoy it. So I want to thank you for your time to join us on Criminal Justice Natters today, and take care and happy holidays.
Thank you so much for having me. I very much appreciate it.
Thanks, Dean. Thanks, Dean. That was a really interesting talk, and I really appreciate you giving up so much of your time to discuss the issues we covered. I know you're exceptionally busy with both academic work and your practice, so I really want to thank you for your time. As Dean alluded to, he's published 2 books recently that they're both available now. His 2013 book, Worse Than the Devil, Anarchists, Clarence Darrow and Justice in a Time of Terror, is out, as well as his second book, Keep the Wretches in Order, which was published in 2019. I will pin hyperlinks to both of Dean's books in the first comments, so you can buy the book. Still time for Santa to bring you a small gift. The books seem excellent. I want to thank everybody who tunes in to watch these videos. They're a real pleasure to do. I do them in my own time, and I thoroughly enjoy them. I've had some really good feedback from you guys who have enjoyed the videos, so thank you very much. Keep your comments coming, and please keep watching. This is our last video now for 2020. I am going to take the Christmas holidays off, so I will return in early January, when we will be joined by Laura Narida of season 2 of Making a Murderer. I wish you a very happy holidays and enjoy your Christmas break, and whatever you're doing, I hope you get time to spend some time with your loved ones and just have a relaxing break. Thank you very much for watching. This is a real pleasure. Take care. Bye-bye.